que podemos empezar.
Good evening. Can we start our meeting? Thank you, technicians, for your help in connecting up in this hybrid setting for this webinar. Well, good evening, everyone, ladies and gentlemen. Thank you for participating and attending this session where we're going to hear some experts about the challenges of digitization for workers as well as for the labor market. The pandemic only put more emphasis and exacerbated further a phenomenon which has been speeding up in a new era of the digital economy, the appearance of new sophisticated technology, sophisticated IA systems and digital platforms as new ways of doing business is having a deep impact on the world of world, whereas this is becoming a real part of labor relations. So we're seeing an increase of monitoring through algorithms and automatic systems, regulation of work, and there's greater pressure exerted on workers. There's less social interactions and greater complexity, lack of transparency in labor relations, absence of separation between separation of private and professional life, which of course often leads to a lack of social protection and makes us more vulnerable. These are only some aspects of the new reality. We're seeing a transformation in the nature and type of work than what we knew, not only in Europe but around the world. This is affecting work conditions as well as aspects related to safety and health at work, and even mental health. Therefore, one of the impacts of digitization is the increase of psychosocial risks with respect to work. Now, we're going to talk about this here this afternoon. There's no doubt about it that we're seeing another type of pandemic, that of sick workers suffering emotional disorders like anxiety, depression, or so-called burnout due to work pressure. Now, digitization should be able to give us tools which could help us make progress in the world of work, but we cannot mix and make personal well-being subordinate to economy. We need to be able to face these challenges and urgently regulate. As socialists, we have made many appeals to the Commission to achieve efficient legislation throughout Europe to try to finish up with exploitation at work. We are committed to improve working conditions so that workers will enjoy justice and dignity. This being said, I'm going to give the floor to the experts in our panel who will give us greater detail as to the impact of digitization and new official intelligence has on workers and men and women in the work market. I'd like to thank all the speakers for participating, as well as the Employment Commissioner and the coordinators for organizing this event, and the Secretariat and all the technicians. Thank you so much. The first speaker for the first panel is Ruben Drans, who's a member of the UGT and has been since 1999, and he's actively participating in the negotiating and approving the right of lay law in Spanish. He will share his knowledge and experience of problems working on platforms and the various conflicts arising for the state. Thank you for participating, Ruben, and you can start your presentation when you wish.
Muy bien, muchísimas gracias.
Thank you very much, Estrella. Firstly, I'd like to thank you for the invitation to these days, these sessions. I'd like to take advantage of being here to share some of my trade union experience with you and share experience with other trade unionists on platforming and the impact of digitization of the labor market. Next slide. When I started working on the digital platforms, the first thing I found was these ideas of the world of business and the employer. What I liked is being your own boss. You can work when you want it, and to enjoy working in a modern image of what this could be. But later we discovered the problem, where we really saw the trick of the trade. Nothing was as we thought, and it was the algorithms of the company and IT experts who organized the work. And the system obliged them to always be present the minute the company needed them. Now, as for working time, they only consider the working time to be the time devoted and to work and on the platform. So each day was longer, and labor skills and willingness. The workers do not accept all the terms of the work relations, because for them platforms impose a constant type of evaluation, and it is very difficult to share experiences. There's a kind of a penalizing system for consumers. Next slide. Here's an example of what I'm trying to say, where you have the assessment systems, like BlaBlaCar, where in the end the customs are always giving their opinion and evaluating these people who are earning their living. As I was saying, it turns out the working time was the time spent doing the task, and this constant evaluation and assessment system pretty much imposes what you have to do. If you don't have a good rating, you might miss out on your turn for work the following week. So, next slide. So then you get a system where you don't have to be a professional for your reputation, because it is the reputation on the platform which determines if you're a good work and you have the proper knowledge. These are two examples of platforms devoted on health. Now, some of these people are not doctors, but there are psychologists and dentists who speak with clients on a video conference, and then what happens, there's a sort of deprofessionalization, because you don't have to certify knowledge. It depends on what the customer thinks, and that's how your work is rated. So a positive rating will allow somebody to keep working. A negative rating could actually stop somebody from working. Next slide. In this context, when you say the words of a professor in Chicago said, it's those who are given it habits. But we have hairdressers, accountants, golf teachers, lawyers, and teachers who would not be able to be supervised, because it is the consumers would be able to monitor poor professional behavior. Thomas Sly mentioned this in a book called Yours is Mine. What's yours is mine? This is such a depersonalized and unhuman working system, where there's no boss. There's a great deal of loneliness that comes up, and we're turning into a system of economic survival, and the only standard is the one imposed by the company, always to make sure that there's a good yield and good profit. We've seen this on Facebook pages where where the workers actually are asking to rent accounts of other people so that they could try to have and to rent their accounts out so they can get some income and keep a good reputation on the platform, because they're always available. The platform is always available. And the company will impose an extreme type of productive model to increase their profits at the detriment of those benefiting from it. They need to get enough money to make the expenditures, but it is very difficult to make ends meet, because the income that you get every day, you have to see whether you can earn the money. And what we're seeing is a way of earning money that is not very clear. Next slide. Now, if you look at the labor world on platforms, we can show you other situations which are similar to what comes up in a different working world, where you'll get similar situations arising where the use of artificial intelligence has increased, and the increase of algorithms are exposing certain problems. I will also show you that we're going to be seeing a language which reflects what the companies are trying to do, like technology, like talent management. Terms like talent management are actually concealing the true motive of the company. For example, when you use algorithms to choose your staff, what we know is that these algorithms are not neutral. There are a whole series of criteria based on certain parameters and data introduced by the company so as to produce this. And this may lead to a situation of gender, racial, or some other kind of discrimination, using data that has nothing to do with their skills as workers, but they spy on the social networks to see what the people express on it, and based on that and these parameters introduced, they reach conclusions as to how we are as people, and we can actually be excluded from the selection process. All of this information is used in companies, and you have kind of a black box to which we cannot exceed. And this is part of the industrial secret of one's companies. With the rider law, there will be certain works councils that will have to be informed as to what parameters these algorithms are using. If I have time, I'd like to elucidate more on the rider law, but I'd like us to go to the next slide first. Well, here we're seeing a case where it turns out that the algorithm has certain situations like Uber, when selecting drivers in England. The algorithms do not recognize people of ethnic minority, like this worker, Deborah, who started reporting on it and had positive results. And thanks to her trade union, there's a campaign starting up to do away with that application of facial recognition, which does not actually recognize ethnic minorities, therefore it's based on racism. Next slide, please. But it's not only just a question of algorithms, but there are games to classify workers. When these tools convert work into a leisure activity, for example, you can work to have fun. Now, through the game, they try and find out what kind of person you are, and then the person loses out on and forgets about time And the same thing happens with those people's picking up the trash. At night, they use an application where you have all the skaters that don't have any kind of character. And so you get the impression that you're playing kind of a poker but you're actually you're playing with an application. So this is kind of a babification of work. And then companies use AI to know how people are actually feeling. If somebody doesn't like something or somebody likes something, and they use programs which are possible to where you can assess people's reactions. And the algorithms are fed with data that they need to function properly. And they need to have good quality data to function properly. And this tool is used in interviews where they ask people to send a video so that they can use that application and reach conclusions as to whether these people are fit to meet the conditions of work for working for this company. And therefore for example, they'll judge whether somebody is sad or happy and if they've got the right personality. Next slide. Now, during the pandemic, distance work has brought about thousands of digital tools to get us to work. Many of these tools have slipped into our private life, as well as being monitors of our activities. You have a program which monitors working time, so it inspects it, and they're always measuring what we're doing while working. But if we stop and think about what we have to do, or if we stop to take some coffee or we take a break, it was recorded in such a way that they will consider that our true working time is only the time that we're connected up and working. Come back to these platforms. Next slide, please. Before I conclude, I need to say that some business decisions can actually affect working conditions of other people's. Now, there has been a great increase in electronic trade, and this has turned out to be a network. And what we have to think, for example, if it is so important to receive a book in 2 hours' time, let me just give you some information that was not published on any media, but the number of truck accidents were 10,974 in 2019, and most of these accidents were with people who were going too quickly. So we see workers from Amazon, and you can see how Amazon works. This next slide, please. You also have to consider that all of these huge technicians are anti-trade unions, and they're using digital mechanisms as they would traditional ones. Now, in this way, trade unions cannot build fair relations between business and employees. There was a court of Wallonie ruling in December 2020 to say that there was that a certain law algorithm was not blind, and they discriminated against those organizing the trade union. This is something we'd known for a long time, but we could give no evidence of this. Now, you have a picture of 2017 when the people met together in these groups, and they put their phones in plane mode, but they were being spied on, and the company got rid of people who were pretty much the ringleaders of these groups. Next slide, please. For this reason, we're proposing a law which would regulate artificial intelligence. So if we summarize the main points that we had in 2 reports published by the UGT on a study of algorithmic decisions in labor relations and an analysis of the European law on artificial intelligence. These were 2 studies that were carried out that I can share with you. They were carried out in Spain. But what I'd like to emphasize is the importance of looking at the algorithms and digital tools which inhibit transparency, which might actually undermine fundamental rights. Next slide, please. Lastly, and then we'll conclude, it's not possible to not mention the current situation on Facebook and reports as to how the algorithms actually were undermining working safely. And an article says if you want to compare Facebook and certain automobile countries, and all these companies denied that their products caused no damage until proof of the contrary. And this is what we've been saying in the UGT, and that people must be at the center of digitization, and proper regulation could help us mitigate some of these negative neoliberal tendencies for citizens, and if they could participate. So let me talk about the rider law. This was a crucial experiment carried out in Spain because it brings about social dialogue, and it came out of participation and work with the trade unions, the businesses, and the Spanish government so that we could regulate a very specific situation. It is true that much needs to be done to improve this, and digital platforms have been bearing a lot of pressure, but at least we've established now a law protecting workers and getting a legislative framework which makes it that the companies realize the cost of this, because one thing that digital platforms are doing was causing investors to leave Spain. A few years ago, 3 companies started out with a new model and complying with the legislation, and we tried to eliminate the previous digital platforms. This new one tried to get rid of certain fraudulent tendencies that these platforms could bring about. We can't say that a person that that works with that has a certain tool is necessarily the entrepreneur. What I'm trying to say is that the rider law has given greater legal security, and this is the major benefit for everyone, because it gives greater security, because it was a result of citizen involvement through trade unions. It gives greater legal security because the investors find out what the true cost is, and the idea is to eliminate unfair competition. We all know what the rules of the game are thanks to it. Thank you, and I'm willing to answer any questions you may have. Thank you very much, Ruben. Thank you for showing us so clearly some of the digital applications used in the working context, which really can have a negative effect on mental health, and that we could regulate using the rider law as an example. Let me give the floor to Rosa Baños, who's a psychiatrist in the University of Invention and director of research on social welfare policies in the university, and she's been researching the potential risks as well as opportunity to digital technology in the working world to try to promote and improve mental health. Go ahead, Rosa. Thank you very much, Estrella. I really would like to thank you for being here to discuss something that is so important. I would like to recall what we mean by health and mental health because it is becoming more and more prevalent. In the year that the apps was founded, they said that health was a complete state of physical, mental, and social well-being, not only the absence or lack of sickness. Now, when we talk about mental health, we said it was a system of well-being wherein the person can realize their potential, they can work productively, and contribute to the community. Next slide, please. Nonetheless, for this reason, we see that health is not only being well, and it's not just a situation of treating people, but it's contributing to the welfare of all people. And health and treatment is not just relieving suffering, but it's helping people pursue happiness and promote well-being. Now, we cannot forget that mental health is determined by many factors, biological, social, and psychological, and well-being should always be understood in a multifaceted way and worked on at various levels. And one of these aspects is labor market, work, the job. The job is a fundamental element for our welfare and is interconnected with our lives, and it takes up a large quantity of our time. It's a source of well-being, but many times it can be a source of discomfort and stress. Currently, a lot of evidence shows that in many fields, work and well-being are strictly interconnected, and work has a great impact on the mental health of people, creating problems which might turn into mental disorders, or it might actually make it more difficult to treat already existing problems. It can swing both ways. Work can affect the emotional and psychological state of the person, but this will also have an important effect on the job. It will influence productivity and lead to absenteeism and have an influence on the other workers and the atmosphere at work. Now, as I was saying, this is a very complicated time, but in a pandemic like COVID, it's not just a question of physical health, but also has a huge impact on our mental health, significantly increasing anxiety, depression, sleeplessness, etc. Next slide. And the pandemic has obviously had an effect on our work, on many occasions changing things in a very sudden way, and it's suddenly changing the way we work. It turns out we've got a certain hyper-technologization of work, which has serious impact not only on the economic environment, but personal, social environment, and impact on mental health. The pandemic saw digitization of many sectors. Now, this had already started up before the pandemic, and there's no way to turn the clock back. And these changes in work, which not only brought about distance working, remote work, but it brought on certain technological innovations like AI, robotics, invasive technologies, these new means of organizing work described by the previous speaker. Next slide, please. All of these processes imply structural and basic changes which affect the fundamental pillars of our system, not only changing where we work, but the whole world in which we're working in, and the way we work has changed. And the difference between working relations between employee and employer. It changes the way we relate to others in our jobs, whether they're colleagues, bosses, etc. And this brings about social and personal changes, and this brings about a whole array of challenges that the person must face, and often they have very scarce resources to deal with this, which will have an effect on the an effect on mental and physical health. Digitization carries with it many challenges, but there's one that's very important because it affects the mental well-being of all workers. And now everything has a price. There's some that tell us that we're pretty much going to be turning into robots, and our working rhythm will be based on AI. On the other extreme hand, there's some that offer a rather ideal image of people who are really happy, and they work when they want, and they only work in what they're really interested in thanks to technology. But digitization brings on many risks. It does offer opportunities to improve physical and mental well-being also. Now on this slide you can see a huge list, which is not exhaustive at all, as to potential risks inherent to digitization. This list was drawn up by the Institution of Safety and Work in 2018, that is before the pandemic. Now, quite likely, this list would actually be longer if it were drawn up today. Next slide, please. Fortunately, this list is another one which is very long, not exhaustive, which spells out certain prevention measures which we could take so that these risks are to get these the impact as positive as we can. Now there are two measures, that is research and getting evidence. Firstly, the Techno Stress, which is a term which has been taken on very recently in 1984, referring to the negative social and social effects on use of technology. That is the discomfort that comes about when we see that there's an imbalance between the demands of technology and the resources and the means to deal with it. And there's stress concepts. So there's techno-anxiety. It's a certain type of techno-stress which has been studied, which could lead to technophobia, a huge fear of technology. And there's also the techno fatigue, mental fatigue because of the use of technology. One type of this is what they call the information fatigue, and that's what happens when you use internet too much. And this can lead us to certain dysfunctioning. Research has found an array of factors which may lead to techno stress for workers. First of all, a technical overload, where the person is required to work more intensively when using this technology. On the other hand, there's the technical emotion when our privacy is being invaded by working requirements and the monitoring systems that these previous speakers spoke about. Then there's techno complexity. we may feel that we have talent, we have skills that we don't have time to learn. So this technology is changing, and we constantly have to be ready to do it. Then there's techno insecurity, which relates to the threats that digitization can actually bring about to our jobs. And there's constant updating, this technology too. Next slide. The consequences of techno stress are many. There can be physical symptoms, sleepiness, headaches, but also psychological problems, depression, anxiety, burnout, and of course, also, this also has negative impacts on the business, like more absence, less quality work. Fortunately, there are ways to try to avoid these problems. Individually, there are certain psychological problems that we can work on to deal with this, and working on promoting efficiency. But we cannot forget that a company must provide and look at the possible repercussions of introducing new technologies and bring about mechanisms to try to prevent the negative consequences and make the adaptation to these technologies easier for the person. Another problem with digitization is what we call the paradox of autonomy, which is similar to what the person who spoke before me said. Most people are trying to promote autonomy, participation, the management of workers, and all of this could promote mental health and protect their mental health. Nonetheless, digitization has an effect on their autonomy. In other words, they're in a digital working context, as the speaker said. If it was regulated sufficiently, then these traditional dynamics could paradoxically turn out to be a risk for health. Autonomy could turn into an obligation rather than being an option. It could be a potential resource, but it could turn into a demand. Work could require autonomy in a working context, which are subject to many types of infections or monitoring, which is not even visible. If you have the whole array of data coming from people, and the data can be varied, and this could have a positive but a negative effect on work. For this reason, all of these accessories to digitization, techno stress, more control, more autonomy, more less family consideration, less free time, longer and longer working days, increasing intensively and as well as extensively. And this brings about stress aspects which could affect mental well-being for workers, men and women. And there's certain more vulnerable groups, like with people with physical or mental conditions, or people who are not that familiar with these technologies, or who are elderly, etc. Next slide. Nonetheless, empiric evidence and research shows that digitization can actually help promote mental well-being. It can help to decrease stigma linked to mental problems, and take on board the importance of mental health and help people with problems, and help identify vulnerable persons and what kind of stress that might bring on these problems, or get rid of them, so they could warn a person if they're in risk, if they're risking, or they could try to prevent worsening of already existing problems. And digitization could help us have more personalized interventions, which could be taken at the exactly the right time. And what's important is access of workers to health services and interventions. And we should extend these services for the job, in the job context. It can't just help give us shortfalls, but digitization can empower workers. But this would be based on multi-level interventions that help the workers as well as the company. As Thomas Inson recalled, the digital world will revolutionize work in mental health like never before. Next slide. To sum up, digitization has affected the tasks carried out by workers, their level of independence, their role in work, and brings about very important challenges which are affecting and will affect mental well-being of workers, and therefore we must know and understand as well as properly manage digitization. Now, digitization can be an opportunity not only to improve working conditions, but to promote the potential of workers, therefore the well-being thereof. It can help us improve mental health for workers, but then strategic decisions need to be made. What do we want? Digitization, which empowers human capitals and uses technology so that workers can develop their true capacities? Or do we want digitization to minimize and control human input, which avoid people having to apply the certain criteria? We must remember that these techniques can be tools which are neither good nor bad. It's how we use these tools. This is what characterizes as living beings. But we've got to be very cautious and evaluate each type of technology in the proper context and use the balance between challenges and opportunities, and look at empiric evidence. What we're doing now must have an impact on the future. Thank you. Thank you very much, Rosa, for describing the two faces of digitization in the work context. I would like to say that we need to look at pros and cons, not just from an individual perspective, but the organizational perspective. Now we shall give the floor to Professor Alessandro Refanti, social professor in Toronto, looking at the consequences of digital applications on the working world, focusing on Amazon, highlighting that this multinational does not always exploit workers, but actually has a negative effect on their health and their lives. Go ahead.
Muchísimas gracias.
Thank you very much.
Thank you for having me. So I'm presenting some, kind of content coming from a report that I co-authored with two colleagues here in Toronto, Lilian Radovac and Taylor Walker. So I'm gonna talk about one single company, and that's Amazon, sort of a symbolic company of some of the processes we are discussing today. Can we go to the next slide, please? Amazon is interesting because it deploys one of the most sophisticated and intrusive systems of workplace surveillance that the world has ever seen. So through its technological firepower, its ability to develop new technology and use it in the workplace, it sets the bar for other companies and kind of depicts a possible more widespread use of these technologies in the future. I want to stress that workers do not have a choice, so they cannot perform the jobs they are hired to perform unless they use the very tools that monitor and control them. And they are monitored not only to make sure that they're productive, so that they make rate, but also for the sake of political control. So workers at Amazon experience this widespread system of surveillance that's based on digital technology and that they cannot really escape from. Next slide, please. So the most, of course, the most well-known example is the Amazon warehouse. So these huge buildings where thousands of workers labor to retrieve and then ship the commodities that we purchase whenever we buy something on Amazon. So in the warehouse, you have the deployment of an array of different digital tools used to control and surveil workers. And I'm gonna focus on the main one. I think the most important one. Can we please go to the next one? So the barcode scanner. In some cases, it can be other kinds of devices like a tablet or a wearable device. But these tools are all used to scan the barcodes that are placed on commodities, items, and thus record their position or record the fact that they've been picked and then sent to shipment, for example. So individual workers log onto the system by scanning their own ID card when they enter the warehouse, and since then, management is able to monitor and control each and every activity that the individual worker performs. So there is a software called Adapt Associate Development and Performance Tracker that controls these devices, that tracks everything from the number of items they pick in the warehouse, so how fast they are, to so-called TOT or time off task, which means any instance where the workers logs off, for instance, because they have to go to the washroom. So workers must meet a certain target, which means that they are supposed to retrieve or place on the shelves a certain number of items per hour. These can vary between 6 items per hour to a couple of hundreds, depending on the kind of warehouse where they work. So it's intense rhythms of work, which are strictly monitored and surveyed through the barcode, and the results of workers' activity are made immediately visible to management, which can then use them to discipline or punish workers. So the scanner is also used for ideological control, though. So, for instance, it continuously polls workers, asking questions such as, "How do you feel about working at Amazon?" And you need to answer something like, "Oh, great," or "Not so great." And this is not anonymous, of course. So the scanner is used both for material control in terms of rhythms of work and this sort of political ideological control. Amazon continuously asks you to confirm that you're happy working there. Can we go to the next slide, please? Delivery work is also strictly monitored. So, of course, once the item we purchased has been retrieved and shipped from the warehouse, there are people who actually deliver it to our homes. So those drivers are also strictly monitored through the use of several different technologies that partially overlap with what we saw in the first presentation. Can I go to the next slide, please? So, of course, they download an app, Amazon Flex being the most common one. The business model is very similar to other gig economy companies like Foodora or Deliveroo or Uber. You download the app, Amazon starts assigning you tasks, you go pick up some boxes and then drive around and deliver them to people's homes. So the app monitors all aspects of people's driving, including tracking their locations, collecting data on productivity, how fast they are, how many boxes, how many packages they deliver per hour or per day. It even surveys the workers' phone usage, so tracking the calls they make or the texts they send. So workers have reported that even just rejecting an incoming call may be logged as an infraction by the app. And again, all this information is made visible immediately to management. Next slide, please. Amazon is also experimenting with AI, artificial intelligence-powered cameras that Amazon drivers are required to install inside their cars. So these are cameras called Drivery that monitor both the road and the inside of the vehicle from the moment the engine is turned on until after the end of a person's shift. So the system alerts drivers about infractions like distracted driving, or it controls that they're not picking up their phone, or when they pick up their phone, is it when they're supposed to do that because Flex is telling them something. It also rates drivers on their driving habits, and again, it submits all data to Amazon's management. Next slide, please. So I also conducted a study of patents owned by the company for technology that may in the future be used in the workplace to organize people's labor and control people's labor. So there will be a wealth of different technologies I could actually kind of present here, including wearable devices that people have to wear and that are basically composed of sensors that capture people's position in space, people's gaze, people's relationships with the robots that they work with. But I'm going to focus on one specific technology that I think is interesting to this idea of technology augmenting or extending management's power. So if we can go to the next slide. So, for instance, Amazon owns a patent for augmented reality goggles that they call an enhanced interaction system. So it's based on an augmented reality headset that a supervisor will wear. So imagine a supervisor working around with these goggles, and whenever they look at a worker, the system automatically recognizes the worker through a face recognition system or other systems to kind of like make sure that a certain person can be coupled with a certain identity in the database. And then as they look at the worker, the goggles present information, real-time information projected onto the natural visual field of the supervisor. So data including demographics, relations with other workers, navigation paths through the warehouse, or status, which may be similar to the stars that the first presentation was talking about in terms of how good a worker is at behaving in a sense within that environment. So this makes workers even more transparent to management. Giving management this power to immediately, in real time, access information about workers' productivity and maybe even other forms of social relationship within the warehouse. Next slide, please. So there will be many more technologies we could discuss in terms of what Amazon deploys in the warehouse or on the road. Amazon uses digitally produced heat maps that geolocate the risk of worker organizing. Body scanners workers have to pass through when they leave the warehouse. AI-powered cameras to make sure that people respect social distancing in the warehouse. So there is quite an array of technologies that Amazon deploys to surveil their workers, its workers, especially again in terms of making sure they abide by the increasingly fast rhythms of work that the warehouse requires to them. It's not just workers. Amazon customers are also surveilled as they order on the website. So we know that our data are collected whenever we use one of those platforms. The conversations, for instance, are recorded by Alexa if somebody owns one of those devices. Also, it's interesting that the workplace is also used as a lab, sort of a testing ground for surveillance systems that will be actually commercialized to the outside world. So, for instance, Amazon sells surveillance systems to both law enforcement agencies. So, for example, it's face recognition software, and also consumers, the Ring home cameras that Amazon produces and sells. Next slide, please. So this system has an enormous impact on workers. So this is something I certainly heard over and over again while interviewing Amazon workers, but there is also a growing movement of workers and unions kind of fighting the widespread and pervasive presence of surveillance systems in the Amazon workplace. So first of all, there is this enormous pressure to make rate. The system also pits workers against each other based on data about their productivity. So, for example, there are competitions to be the fastest worker. Management uses stress, in a sense, as a way to control workers. So because their rate is always calculated and made available to workers, because their job may depend on their ability to make rate, because they're pitted against each other, many workers report stress as a major part of their experience of working at Amazon. And then, of course, Amazon facilities have higher than average injury rates. So as the speed goes up, because of this surveillance system, injury rates also go up. So there is a sort of a health and safety crisis, in a sense, at Amazon, which is driven by these technologies. And of course, some of the most vulnerable workers are disproportionately affected by these systems. So precarious workers hired through staffing agencies, this amounts to more or less, I want to say, give or take 50% of the workforce in Amazon warehouses. Or misclassified subcontractors that work through apps like Flex are more vulnerable to Amazon surveillance systems because the threat of losing their job is much higher than the one experienced by a full-time worker, for instance. Women and visible minorities can also be more vulnerable towards Amazon surveillance systems. Next slide, please. So in response to its safety crisis, in response to the rates of injury going up, in response to all the public attention towards that, in response to worker burnout being so widespread at Amazon, I just want to mention that there is an entire genre of YouTube videos, why I quit Amazon YouTube video, mostly because of burnout, is an entire genre on YouTube. So in response to this crisis, Amazon deploys technological fixes or tries to make workers responsible for their own mental and physical health, rather than, for instance, reducing the rhythms of work or reducing the presence of surveillance in the warehouse or in people's cars. So just a couple of examples. A few months ago, it introduced these Amazon boxes. You can see in the picture here, where workers could practice mindfulness, during or after a punishing shift. So you could just lock yourself in the box, listen to some, new age music, and maybe relax a little bit. Or it asks people to download its Working Well phone app, which basically reminds workers to take care of themselves in terms of sleeping enough, eating well, and so on and so forth. So it unloads the burden of taking care of themselves onto the workers, in a sense. Jeff Bezos even announced the introduction of algorithmic tools to monitor which jobs workers are performing, and then shifting them across different jobs in order to reduce musculoskeletal risk. So they are, instead of making the job easier on them, reducing the speed of their jobs, Amazon is planning to introduce yet another technology that surveys workers and then tells them what to do. Next slide, please. So I'm just going to end by saying that I think that these pervasive digital surveillance systems are not only a threat to workers' well-being, but also a threat to workplace democracy. They've been used to prevent unionization efforts and resistance within Amazon warehouses, especially. But workers across Amazon's global operations system have protested this widespread use of surveillance and its repercussions of labor. And I think we need to pay attention and support those workers. Thank you very much. I'm going to wrap up here.
Muchas gracias, Alejandro.
Thank you very much for telling us so many details, the problems we were suspecting. The customers work a lot with Amazon, but they don't really see what's going on. So this concludes the first panel, so I'm going to turn the floor over to Hannes Jongerius, who's the S&D coordinator of the Social Affairs and Employment Committee. Thank you very much.
And thank you, Estrella. Thanks also to all the speakers. Am I using the right microphone? I'm looking at the back and the... It's okay. Thank you for the first three speakers, because I think indeed this was helpful to sketch what's happening not only in the trade union world, in the world of science, but also in practice with Amazon. We called the first panel Management and Control. The second panel is titled Beyond Disruption, because I think it would be now interesting to hear from the experts in the second panel what they picked up from the previous speakers, but also what their suggestions around legislation will be, because I think it's clear now that the digital world is asking for new legislation to strengthen workers' rights. I'm going to shortly introduce the experts and then give the floor to each of them. We've got 3 speakers in this panel. The first one is Jeremias Adams-Prassel. He is professor of law at the University of Oxford, particularly interested in the future of work and innovation, and he has published several books on the gig economy. And he's leading, since this year, a research project on algorithms at work, funded by the European Research Council. Our second speaker is Oliver Rutger. He is the head of Uni Europe, the European Service Union, as the regional secretary. He's also a member and a former vice president of the European Trade Union Confederation, ATUC, and he sits in the executive board of Uni Global Union. And last, Xionghaiji Domokos serves in the Californian state legislature as the chief of staff to Assemblywoman Lorenza Gonzalez, who is a Democrat representing the southernmost assembly district in California. And we know that in California, legislation has been introduced. She managed the Assemblywoman labor and employment legislation, staffed on her bill, such as Assembly Bill 5, which deals with employment status of all workers in California, including platform workers. So I think we have a nice round of experts, and I think the first one I'm going to give the floor for, with an eye on the clock, some 10 minutes. Can Jeremias take the floor and tell from his experience what we should do next? How do we get beyond disruption?
Thank you very much indeed, Agnes. Thank you very much, Estrella, and to everyone in your teams for putting together this really interesting afternoon today. As it is the case when talking about technology, I had prepared a PowerPoint, but I now can't share it. I'll just speak to you and take you through some of the ideas. And there's really 3 things I want to talk to you today over the course of the next 10 minutes or so. First, I just want to quickly think about what are the kind of challenges that are inherent in the problems that the 3 really interesting and challenging papers we've seen in the first session are. And then I really want to focus on, as a professor of law, what are the kind of legal solutions that we can have to those problems. And I will briefly look at potential existing solutions within European law, because I think it is important for us to recognize actually that even already within EU law, we have at least certain elements of a solution. And then I will focus the main substance of my presentation on the proposed AI regulation and try to look at some of the very few potential positive things about it, but then also really focus on the challenges, both in terms of the internal dynamics of the regulation and also its broader constitutional problems within the union legal order. So let me start very quickly with my first point, this idea, what are the kind of challenges we're facing? And actually, I suggest that we take a step back from the various detailed discussions and analyses of people analytics. What we're seeing is really 3 challenges. First, a challenge as regards workers' data, the immense collection of those bits of information, but also the fact they're then machine readable and very easily processable in all sorts of ways. Second, the kind of technologies we now use to analyze and understand that information, in particular the use of sophisticated machine learning technologies, which are not necessarily any more explicable or understandable. And then third, and I think the last presentation in particular showed that, similar to the first presentation in very great detail, actually the degree of control that can now be exercised, both in terms of direct employer control, but also through the gamification of various other elements of algorithms at work. And as we saw, for example, also in the presentation of Professor Baños Rivera, these kind of technologies have very serious implications for the quality of work. And so as a lawyer, what we need to think about is, what can we do both in terms of existing and potential future employment, social, labour law to challenge some of these negative impacts that technology can have at work, ensure there's a level playing field and basic decent working conditions for all. Now, if we look second at the existing elements of EU labour law, the broader social acquis of the Union, actually there are some elements that could help us avoid some of the worst problems that we see with algorithms at work. So, for example, the very recently enacted directive that deals with transparent and predictable working conditions protect workers in zero-hour style or some of the most extreme gig economy scenarios that we see, for example, through rights of notification in advance, through the right of protection when they, for example, deny or turn down jobs, various other elements in terms of predictability of working conditions. We also have very well and deeply established within union law a broad anti-discrimination acquis, both at work and beyond. And again, when it comes to at least some of the worst problems that we see with algorithmic bias, with algorithmic discrimination, there's at least some potential for the current EU anti-discrimination law framework also to provide solutions. And finally, of course, we have the General Data Protection Regulation, which again, as current litigation shows, has some potential to alleviate some of the worst features. I think it was the first speaker who's already alluded to ongoing lawsuits in the Netherlands, where cases have been brought against both Uber and Ola by drivers alleging automated deactivation, which would be contrary to Article 22 of the GDPR, which makes it illegal to rely on entirely automated processing in contexts such as work. So what I want to say, just by highlighting this area briefly, is that we shouldn't give up entirely on EU law as it stands. There are little pockets, but they have lots of issues. They have issues in the sense that they're not necessarily designed for a world of algorithmic management. They have problems that they sit in different regulatory areas and don't necessarily connect up with each other. So what we end up with is, whilst there are sort of little islands of regulatory efforts at the moment, we don't have an overarching structure of regulating AI at work. And that, of course, brings me to the third point of what I want to talk to you about for the remainder of my presentation, and that is the recent proposal by the European Commission for a new AI regulation, or an AI Act, under this broader heading of a new European approach to artificial intelligence. This was published late last spring and has since been already the subject of intense academic debate. What I'm talking to you about today is work I'm currently doing with a colleague at UCL, Professor Michael Veal, and it's also very soon and already starting to be the subject of very intense public debates in the European Parliament and in civil society more broadly. And so when we look at the proposed AI regulation, I think we need to look at the good, the bad, and the ugly. Let's start with the good. Why not? Let's have a few bits of good news to start with. Well, one thing the regulation very explicitly recognises in its regime in Title III and the linked Annex II is an explicit statement that the deployment of artificial intelligence in the world of work, whether it's for hiring people, for managing them, all the way through to firing them, is very much a high-risk context. It's a context where significant fundamental rights are at stake. It's a context where there's a lot of risk that such rights might be violated, that we see serious immaterial harms to the workforce. And I think it's important that we recognise this as a positive, this explicit recognition that AI at work can have advantages, but also can have some very serious downsides. And when they then look onwards into the details of Title 3 of the regulation, again, at first glance, you see some potentially quite positive facets. You see the various requirements, whether it's transparency, whether it's reporting requirements, whether it's requirement to have accurate and de-biased data, requirements in terms of the overall human-in-the-loop provisions that need to be there, doesn't necessarily look very bad. However, you need to read on into the sort of drier technical detail to recognize the much more problematic aspects. And that is where we turn from the good to the bad and the ugly. Or to be more precise, we have to think first about some of the internal flaws that are problematic within the very scheme the regulation proposes. And then we need to move on to what I call the external, or indeed the constitutional flaws, which are really the hugely important concerns we need to discuss. But let's start first with a sort of narrow question, the internal challenges, the internal problems of the AI regulation. Why do I suggest it's deeply flawed? Because the blueprint for regulation that was chosen doesn't make sense in the world of AI. The blueprint that was chosen was what we know as the new legislative framework. The new legislative framework, a very successful way of regulating the internal market when it comes to product standards. So for many decades, European regulation has ensured that coffee machines don't blow up, that chainsaws don't chop off our legs, that PPE complies with certain basic safety standards and actually protects those who use it. And the mechanism through which EU law has achieved this is essentially the new legislative frameworks. The details are incredibly intricate and detailed. I won't bore you with them, but essentially what we have is an outsourcing of standard setting to technocratic experts, and then a scheme of certification, often self-certification, of people who comply with it. And so what comes out of it is what we all know. It's the CE logo that's on all sorts of products, essentially says this complies with European standards, and you know pretty much therefore that it will be a safe product. So what's the problem? Why shouldn't we be happy with this? Well, there's a couple of reasons why I'm quite concerned about the use of the new legislative framework when it comes to artificial intelligence. First, because actually what we're looking at here in terms of the dangers that AI poses, we're not just talking about material harms. Indeed, the core issues we've been talking about today are various immaterial harms, the violation of fundamental rights standards of decent working conditions. Second, given the broad and deep societal impacts of artificial intelligence, I'm not sure we can necessarily be confident to just rely on outsourced technical standard setting when it comes to much broader questions of societal and technical impact. And finally, there's also this issue that the new legislative framework does not foresee any role for parties other than the users of products, which of course in our context would be employers deploying the systems. So there is no access to any of this information for individual workers. There is no access to any of this information for trade unions, indeed social partners much more broadly. And so the entire sophisticated apparatus which we have within the treaties for consultation, for joint social partner legislation, in Article 153 of the TFEU onwards, that entire regime would be completely ignored, would be completely sidetracked by this new mechanism. And finally, of course, when you look at the details of Title 3, through the self-certification using private standards, actually the various nice provisions outlined earlier would not necessarily ever be applicable. Instead, producers of the technology, developers, could simply go out, private standards, and then self-certify compliance with it. So looking at the scheme itself, it won't work. It won't make a big change at all. So you could say, okay, well, it's not going to do much good, but it also won't do much harm. So why is Jeremiah so worried about this? Well, here we get to my final point, and that is the constitutional dimension of the proposed AI regulation. The constitutional dimension of a regulation that takes as its legal basis Article 114 of the TFEU, a measure for internal market harmonization, which can be used, and explicitly, if you look at recital 1 of the measure as proposed, is here being used for maximum harmonization. Maximum harmonization, translated into more straightforward terms, meaning that member states will not be allowed to set down or develop higher protective standards, whether that's in employment law or in consumer protection, in environmental law, or a whole host of other areas. So the first problem is that the standards we see laid down, essentially self-certification of private standards, are not a flaw for the regulation of AI. They're actually a ceiling above which member states are not allowed to go. And even more concerningly, it's not just as traditionally this product itself that's being regulated, the tension on the chainsaw or what needs to be inside your PPE to be a safe face mask. It's not just the product standard, it's also the use of the product. And what that means is that the preemptive scope is very, very wide indeed. Under the regulations currently proposed, you could easily imagine arguments that German provisions on works councils and co-determination would no longer be allowed to apply to artificial intelligence at work. You could think about the riders law, which we've already heard about, recently enacted in Spain, which also, amongst other things, regulates access to algorithmic information, being seen as an unwarranted infringement on the maximum harmonizations in the regulation. And the same is true for all sorts of other potential collective and individual measures of employment law, where they will touch on algorithms within the scope of the regulation. So that, I guess, then, is my chief concern about the AI regulation. Not only is it in substance not going to achieve very much in terms of protection, at the same time, it is going to knock out and prevent any form of other regulation of artificial intelligence in the workplace, deny the chance for innovative experimentation across different member states, and ultimately create a deregulation that is completely out of sync with the overall approach of EU law, always carefully to balance the internal market on the one hand and the social goals of EU law more broadly. So in short, for a long time, I and other colleagues have been trying to work out what could we fix, what could we tweak about the regulation. But I think the safest way forward is actually to delete the employment provisions from the current Title III and to start working instead on an employment-specific regulation of AI, recognising the context specificity, and also, with my hat as an EU constitutional lawyer on, the little fact that it says in Article 114, the legal proposed basis for the AI regulation, that you're not actually allowed to use it for employment law or the rights of workers. That's Article 1142. So you've got both a strong legal and a broader constitutional argument that actually, insofar as the world of work is concerned, absolutely, we need regulation at the European level. AI is not a challenge that any one country can tackle by itself, but it needs to be context-specific and needs to be much more fine-grained and thought through than what the current proposal has. Thank you very much indeed. Please reach out by email or on Twitter at Jeremias Prassel if you want to discuss any of these items further.
I thank you very much, Jeremias, for this offer, because I think we're going to keep you to this this offer, because it's helpful to, on the one hand, not forget existing legislation, which is there, and we tend to overlook if we are talking about the gig economy. But it's also clear what your recommendation on the AI regulation is. Get rid of the employment part and design a new employment part. And there, I think we can use every help which is on offer. So thank you for your clear analyzing of this situation. Can I then now move to Oliver Rutger, who is from Uni-Europe's perspective, perhaps can also answer the question, what do you think is the best way forward? How do we get beyond disruption? What should we regulate? Oliver, floor is yours.
Thank you very much. Thank you, Agnes, Estrella, first of all, for organizing this seminar and then also inviting me. Madams and gentlemen, Augmented exploitation, AI, automation, and mental health at work. Your webinar today is very topical. Augmented exploitation is accelerated by digitalization and boosted by the pandemic. Surveillance and control of workers is sneaking into ever more jobs. From cleaners, delivery drivers, warehouse workers, contact centers to offices, in particular when you work remotely from home. This augmented exploitation using technology reminds me of the Borgs in Star Trek. Do you remember them? They moved around the universe and subjugated civilization. Their motto was, "You will be assimilated, resistance is futile." When I look at platform companies from the US to Europe, they are out there with express purpose to make the world workers, business partners, society, and the law adapt to them, not the other way around. The main driving force in this racket is Amazon. Indeed, I'd say their motto is, "You will be Amazonized, resistance is futile." Its business model is about dehumanizing work, making workers extensions of their business system. At this stage, the lead in surveillance and control is Amazon. In the summer, we published as Uni a report, the Amazon Panopticon. It catalogs the various methods Amazon uses to pile pressure on workers through extreme surveillance and monitoring. Individually, none of these monitoring methods are entirely new. Yet the culmination of all of Amazon's workplace technology creates an environment of control unheard of in the recent past. The company's invasive tactics are spreading rapidly across fulfillment centers in e-commerce and to other employers in industries as well, and pace and scale previously unseen. Therefore, I want to use Amazon as a starting point for us to explore what is happening more generally today and what can be done about it. However, others are not far behind, like Teleperformance, the contact center behemoth, or many of all those other platform companies. The Amazon model, the Bezos model, is based on a dystopian vision where employees are relentlessly monitored, evaluated, and subjected to high pressure and grueling conditions. This model is so inhumane that, as the New York Times recently reported, Amazon burns through workers so quickly that executives are worried they'll run out of people to employ. As an aside, looking at Europe and its demographic development, I doubt this business model is really sustainable. I really appreciated the examples Ruben Runs and Professor Delfanti gave in the first panel. Let me add some. To start, one example of algorithms' power. Amazon drivers have been fired by the app for minor mishaps that a real manager might have ignored. That said, 10 years ago already, Amazon warehouse workers were fired for being too often idle in 10 minutes, even without AI in Germany. Another example is the call center industry. Alongside the rapid introduction of telework, companies are deploying sophisticated monitoring programs into their workers' homes, essentially taking the panopticon from the warehouse and putting it in employees' bedrooms, kitchens, and if they are lucky, home offices. The catch? These workers are also required to be monitored non-stop, some with cameras turned on for the entire working period. Of course, this also means an invasion of the privacy of their homes. And the next question is, well, assuming that we don't want workers to spend 40 hours a week or more turning their bodies over to a minder or cameras in our bedrooms, what can we do? Workers are voting with their feet. Turnover is high at both Teleperformance, the largest call center employer, and Amazon with 80% respectively, 150% turnover annually. And yet fleeing a job is not a long-term answer, as this dehumanizes technology increasingly becomes the norm everywhere. And this is not only in platform-related jobs, but really everywhere. Regulators bemoan that the technology is too complicated to police and that the tech companies will find a workaround to every rule. If workers give consent, it's okay, employers ask, but with the unequal bargaining power of a single worker, free choice is exactly on the menu. Unions across Europe have called for the European Union to regulate the danger of abuses in the use of artificial intelligence at work as part of the upcoming directive on digitalization. The previous speaker really pointed out where the weaknesses in the AI proposals at European level are at the moment. And I think we need to address it. But I think what is really important. Before we figure out how we can do this and what is ethical for the industry, we basically have to come up with what we have already in place. So what we want to do as trade unions, there we're looking also for you in the European Parliament, for the EU, for governments to empower us, for unions to be empowered to negotiate in the terms of artificial intelligence. This must include how much workers' information is collected and the storage of this data. Unions should also influence the design of the algorithms that use this data and the production targets and disciplinary actions which may result from it. Unions have traditionally negotiated over the introduction of new technology and its implications for workers, including the capacity to monitor. When I look at Professor Adams-Pressel comment that this might all be not possible with the new AI legislation proposed, then we really have a problem. I mean, we have some examples like the Spanish unions who have recently won the right to negotiate over the algorithm in the app-based taxi industry. If this is no longer possible because there is an EU law, then we really have a problem, not only in the sector of AI, but that would actually bring about even more anti-European feelings across Europe. What we can start to see, however, is that unions, competitors and governments wise up and are starting to close the loopholes that Amazon, Teleperformance and others are exploiting. That's a big part of their business model, evading rules that apply to their competitors. And we don't have to go the same way, but we have to oppose it. Second, and especially where there is no collective agreement, which limits the practice, regulators should ban cameras and other forms of non-stop monitoring at work. Coal miners, typically well represented by unions, have long ago accepted cameras in the coal seams as a form of protection in the event that there is a collapse or some other unforeseen event which affects the safety of everyone down below. And yes, indeed, there is room for cameras if there is a real health and safety concern. But unless there is such a concern, cameras, listening or observation tools should never be allowed on a non-stop basis in a worksite. Third, health and safety inspectorates and regulators should recognize the psychic and physical impact of this new technology. They should develop tools and rules for ensuring that the workplace remains free from back-breaking targets and psychic terrorism. We must put a stop to such tactics that degrade workers in body and spirit. All workers should have democratically elected health and safety committees on the job. Fourth, humans must remain in command of the consequence of algorithmic management. Any disciplinary or dismissal decision must be taken by a human, not an algorithm. Jurisdiction which already forbids unfair dismissal should embed this point into the legal framework. For those without any existing regulation on this issue, now is the time to step up and change course. Fifth, Amazon in particular is a major recipient of public contracts. A key demand for Europa is that public authorities use the purchasing power to force changes on companies. This also applies to Amazon. Currently, we run a campaign, no public contract for companies without collective agreement. We fight for a change of the law that makes this rule compulsory for everyone. But we don't need to wait until the law changes. Public authorities can already make this demand a condition for a public contract today. With collective agreements, Amazon, Teleperformance and all those other companies would not have a chance to exploit workers and undermine Europe's social model. I'm glad that both of you have signed up to our pledge in terms of public procurement and collective agreement. Let me conclude by coming back to the box and Star Trek. Let us all work together and tell Amazon and all the others, you will be Europeanized, resistance is futile. Thank you.
Thank you, Oliver. And thank you also for this clear message in the direction of the platform companies, which gives me the opportunity to now say, let's go from Brussels to California. And let's give the floor to Suhanchis Domalkas, because in California, there has also been some fighting back. So please tell us your good stories from the United States so that we can see what we can learn from you. I give you the floor. Thanks.
Thank you very much for that kind introduction. Good evening, members and guests. First of all, huge thanks for putting together this timely discussion. It's really an honor to be able to share a bit of our perspective all the way from California. Again, my name is Shivangi Demokos. I'm Chief of Staff to Assemblywoman Lorena Gonzalez. She has served as a progressive Democratic lawmaker in the California State Legislature since 2013, and I have the privilege of managing the Assemblywoman's labor and employment legislation. In recent years, we've really been closely examining how warehouse workers in particular have become vulnerable to new emerging technologies being introduced in the workplace with little to no oversight, as you know, from state and local governments. These are some of the most dangerous jobs that we have in California. A recent study by UC Merced actually found a 57% increase in deaths among warehouse workers in 2020. The trend is consistently trending upwards. And so we wanted to know why. Why is this work becoming more dangerous? And how is technology potentially driving this trend? And rewind to exactly 3 weeks ago, Governor Newsom of California signed Assemblywoman Gonzalez's Assembly Bill 701 into law. And so with AB 701 for the first time in the United States, we are finally acknowledging that it's time to start regulating the use of algorithms in the workplace and better understand how their use impacts the nature of work, how it's contributing to injuries and labor violations across the warehousing industry. While the law is actually not set to take effect until January 1st, today I'll just offer our experience of working to pass this law. I will just elaborate a little bit on the specific problems we were targeting and discuss really how this is laying the foundation for future regulations of artificial intelligence going forward. And so you all can understand why Assemblywoman Gonzalez was compelled to introduce this legislation. I will very, very briefly touch on the application and impact of algorithms that we've seen specifically in California warehouses. But Oliver and Professor Delfanti have already done an expert job of summarizing Amazon as a case study, so I will move quickly. I just want to specifically highlight this staggering statistic that really puts things in perspective. Amazon workers are injured on the job at twice the average rate of the overall warehousing industry and 3 times the average rate across all private employers in the United States. Their injury rates are outpacing competitors like Walmart and the United Postal Service. And from what we know now, the injury rates in facilities that use robots and automation are 54% higher than non-automated facilities. And all of this is suggesting that the way that Amazon uses automation to maximize work speed is contributing to these worsening injury rates over time. And as folks have talked about, these production quotas, they automatically set and adjust an algorithm that cannot take into consideration the toll of this backbreaking work on the human body and mind. These workers are being disciplined and they're being fired. We've heard often without any supervisor, human supervisor, ever being involved. If a worker accrues more than 6 to 10 minutes of time off task, they do not meet the production quotas, they can be fired, and these quotas constantly fluctuate without any prior notice over the course of a maybe 10, 12-hour shift. This is one of the problems that we're tackling specifically. And secondly, these harsh work conditions are really allowing workers to not fulfill their basic human needs, with many Amazon workers describing mental anguish of foregoing proper hydration so they can avoid using the restroom. We've heard in California, all the restrooms are 5 to 7 minutes away from the work site, and they traditionally only have a 10-minute legally mandated rest break to begin with. This is precisely why we continue to hear stories about desperate Amazon workers urinating in water bottles. And we just need to take a step back here and look at the fact that Amazon is setting the worldwide standard for what is considered competitive in one of the most physically dangerous jobs in the private sector. All the while, they've become the 5th largest Fortune 500 company in the world. They're expected in the United States in just a matter of 1 or 2 years to become our largest private employer. So if governments across the globe do not oversee the implementation of these technologies from the outset, we are really risking the safety of all warehousing jobs, even union jobs, as other companies must follow Amazon's lead and they're forced to shift their business models to remain competitive. This persisting situation, obviously, it's not sustainable, and we knew in California legislative intervention was necessary, really, to contend with all of this overwhelming evidence. So I will just dive right into AB 701. This bill was really about creating a real policy discussion around how to prevent the use of technology as a tool to further exploit workers instead of improving their working conditions. And without any existing standards in our state laws about production quotas or what is a safe pace of work, corporations, they've just had a clear opening to take advantage of this gray area in our labor laws. And it's at the expense of workers and their health, clearly. These algorithms really are just serving as a vehicle used to automate how far corporations can really push workers past the breaking point. So Assemblywoman Gonzalez worked on this legislation as a foundation-setting policy to better equip California to tackle these emerging issues going forward, and also providing workers immediate rights and protections while we're building towards those larger standards. So under the new law, either when a worker is hired or before January 31st, 2022, large warehouse employers must be transparent with their employees about providing specific written descriptions of their production quotas, along with any disciplinary actions that they can be subject to if they don't meet those quotas. And I really want to just point out that in California, non-union jobs are even more precarious because workers across the board can be fired without cause. They're at-will employees, unless our labor laws specifically deem an act by an employer unlawful. So we wanted to create a baseline of protections. AB 701, it clearly states in the law it is unlawful for a warehouse employee to be disciplined for failing to meet an unsafe quota, which can be a quota that violates health and safety laws, violates the right to meal and rest breaks, or just prevents an employee from using the bathroom. And this was really transformational for any current or former warehouse employee that believes that their production quotas have caused health and safety violations or prevented the use of rest breaks. AB 701 provides workers the right to 90 days of their personal work speed metrics that are collected by electronic monitoring systems, as well as written descriptions of every single quota that the worker has been subject to. Now, this is critical for workers to have access to their own data when they're filing a complaint with the government enforcement agency over the use of these technologies. This information helps to build the worker's case with concrete evidence to actually demonstrate the risks that these dangerous quotas are posing to their safety. And then if a worker actually faces discipline from their employer, within 90 days after exercising their rights to get this data, whether they are complaining to their supervisor or an enforcement agency about an unsafe quota, AB 701 creates a rebuttable presumption that any adverse actions they face, that the employee faces, those are considered unlawful retaliation. And the purpose of this, of course, is to protect a worker and their job in the immediate period after they speak out, after they have the courage to do that. And it automatically takes the burden of proof and takes it off the worker and places it on the employer. So if they are disciplining the employee, they have to provide a justifiable, reasonable cause for doing so. And finally, under the law, both government agencies and workers themselves actually have the ability to go to court and pursue an injunction to reverse any retaliatory actions that they've experienced. They can halt abuses in the workplace, like suspending an unsafe quota enforced by an algorithm. This is just another example of why having that access to the data that's being collected by these electronic monitoring systems is so beneficial to use as evidence. And for our state enforcement agencies, this is the first time they will ever have the authority outright to inspect any warehouse quota record, any employee's work speed data metrics. And the law specifically requires that our agencies evaluate any warehouses that have above average injury rates to determine how the algorithmically enforced work quotas can be contributing to those contributing factors, to those injury rates that are increasing. So that is essentially a summary of the law. Our office's partnership with the brothers and sisters in the labor movement was really essential in pushing this effort across the finish line. They helped show a lot of the lawmakers the difference that union representation can make in bargaining over working conditions that are so consistently impacted by these emerging technologies. We met with Amazon after Assemblywoman Gonzalez introduced this legislation originally in January. And during the meeting, an Amazon official actually specifically raised concerns that they thought employees would abuse their more generous allotments of time for using the bathroom. And before she spoke too much, another official in the meeting attempted to immediately walk back that statement, but it was already too clear that they took issue with how the rights under AB 701 could interfere with their ability to control an employee's work speed. Whereas, the legislation, all it does is it protects a worker's basic human needs. Publicly, really, the Amazon avoided commenting on the measure. For the majority of the legislative process, we were faced with really intense opposition from two large business factions that were trying to, basically kill the effort from the start. Our Chamber of Commerce represents large warehousing operators, and so we negotiated directly in good faith with that group. And there were some major compromises that I just want to point to that actually removed some of the most reasonable aspects of the legislation that I think are worth revisiting in the future. And those are that we need to require warehouse operators to provide workers with sufficient notice in real time when production quotas are changing. And secondly, allowing employees an absolutely unrestricted right to request their personal work speed metrics, even if they don't have a cause of action. Now, the second business faction was the California Retailers Association. Amazon sits on their board, and they put forth an extensive paid campaign against the legislation, but that was obviously ultimately not successful. But going forward, our labor enforcement agency, in 1 year from January, they're going to be releasing a public report with enforcement actions that happened under this law. They're going to provide better quality data about who were the worst corporate offenders, and we're really ultimately hoping to use that enforcement data to develop evidence-based standards on safe work speeds and limit the ability for algorithms to take unilateral disciplinary actions against employees. And I think really it's never been more clear in all of the discussions we've had in this amazing session today. The future of work, the future of workers is at stake. Really look forward to having more discussions on this topic and happy to answer any questions. Thank you for having me.
And thank you very much for your story and for the good work you're doing over there in California. So my thanks to you and to Lorena Gonzalez, sorry to mispronounce her name. I think it's very important that people take the lead in pushing for more decent working conditions. And I think your story is quite inspiring. I must say, I had not realized that not only the threat on mental health, this was the starting point of our conversation, technology and how it affects mental health, but that it's also have such a big influence on the fatalities at work. So I think with this emergence of this new technology, we see changes in a lot of issues around work, around the mental health, but also on the protection of health more in general. And I think next to the fact that perhaps we could make better use of the existing legislation, it's also important to push for new legislation, new binding legislation on healthy and safe working environments and decent working conditions. With an eye on the clock, I think now it's time to say goodbye to all the speakers and thank you very much for your offer that you are willing to think with us on the next steps. Thank you for indeed encouraging us as lawmakers here in the European Parliament to push a little bit further and harder because it's really necessary. Thank you, Estrella, for taking the initiative of organizing this webinar. Thank you to all the interpreters and the technicians. There is enough food for thought. There is also inspiration that a well-targeted fight could also lead to big wins for workers. So thank you also for the speakers. And yes, we will come back to the speakers for the next steps we're going to take. And on that note, I wish you all a pleasant evening. And I think in California, a pleasant morning, perhaps. A pleasant morning to California. Thank you. Bye-bye.